Hello friends, today let us have a discussion with respect to how the judges of the Supreme Court of India and High Courts are being appointed. Generally speaking, the institution of judiciary is having high amount of integrity, and moreover they are there to ensure that everything happens as per the constitution. Therefore, we should know how the judges of the Supreme Court and High Court are being appointed. Article 124 deals with respect to the appointment of the High Court, Supreme Court judges as such. So, Supreme Court judges are being appointed based on some model. In case of the entire world, India is the only country where judges are appointing the judges. Normally speaking, this type of methodology is unfound anywhere. There will be some amount of examination, some amount of requirement to be elevated to the post of judge. But in India, the brother judges will be appointing the next successor who should come and occupy the chair. Therefore, some amount of transparency is missing. The genesis of the judicial appointment started by way of Kesavananda Bharati case judgment. As you all know, it is one of the landmark judgment given by Supreme Court of India on April 24, 1973. Kesavananda Bharati case has given a new doctrine which is called as Basic Structure Doctrine. That judgment was made by almost 13 judges, where 7 gave a favorable opinion and 6 were not willing to support the judgment. In that case, post the Kesavananda Bharati case judgment, an appointment was made for a person called as A.N. Roy, wherein which he was given the status of Chief Justice of India despite having some seniors. So, by overcoming the rule of seniority, they made random appointments wherein which one person was given the status of Chief Justice of India despite being a junior. Therefore, the commotion emerged wherein which they had trouble to know how they are making the appointments for the post of judicial. And this matter can be easily analyzed by way of having an idea with respect to the judge cases. There are 3 important cases: first judge case, second judge case and third judge case. These 3 cases are having relevance to understand how the judicial appointments are being made. Normally speaking, in case of the judge case, what happened and what is the genesis, we will deal one by one. Number 1, with respect to the first judge case. In the year 1981, the first judge case emerged, wherein which they had a doubt with respect to what does the word consultation means. So I said Article 124 of the Constitution deals with the appointment of the judges. In this matter, they say that the President shall appoint the judge after consultation of the Chief Justice of India. Therefore, the doubt emerged wherein which they had an issue with respect to the word called as consultation. In first judge case, the Supreme Court of India declared that the word consultation means mere exchange of idea. So, mere exchange of idea means there is no need for the President to have any binding task with respect to the list given by the Supreme Court. Normally, they will refer some list of members for the elevation for Supreme Court judge. As per the first judge case, the judiciary made a statement that any name recommended by the Supreme Court of India is just exchange of idea. Whether President can take that list or he can make his own fresh list. So this was the first judgment given by the Supreme Court. Later on, the second judge case emerged after 1993. So in the 1993, second judge case is considered to be one important judgment with respect to the appointment. Here, they have changed the meaning of the term called as consultation. Hereafter, the word consultation means concurrence. Whenever we use the term concurrence, it denotes we have to definitely obey what they are saying. Number 2, judiciary has given a new term which is called as Collegium System. Often we encounter this term in the newspaper and current affair content. Therefore, we should know the term what is Collegium System in case of Indian judiciary. Collegium System denotes always the term collegium will have a meaning with respect to the appointment wherein which Chief Justice of India plus 2 senior most judge of the Supreme Court all the three put together will forward the list of the advocates or the number of persons who are eligible to become the judge of Supreme Court. Only on that list the president shall make the appointment. Number 3, the collegium system which was introduced in the second judge case is having relevance even till today. And in the second judge case, they are given a new meaning that if the Chief Justice of India, without consulting 2 senior judges, is making any recommendation, that will not come under the meaning of the term collegium. Then afterwards, in the year 1998, they went for a small change, and that is called as third judge case. In third judge case, they declared that originally we said 1 Chief Justice of India and 2 senior most judges of the Supreme Court. Here afterwards, for all type of Supreme Court appointment, it shall be 1 Chief Justice of India and 4 senior most judges of the Supreme Court. So originally it was 1 plus 2. In the third judge case, they made 1 plus 4. Simultaneously, they declared for any type of appointments, transfer and all for the High Court judges, it will be based on 1 plus 2 model. So 1 Chief Justice of India, 2 senior most judge of the Supreme Court, they can handle all matters relating to the High Court. But for the Supreme Court, it will be based on 1 plus 4. Later on, the Parliament went for an act called as 99th Constitutional Amendment Act. This introduced NJAC, National Judicial Appointment Commission. The parliamentarians were now trying to have an influence in the appointment of judges. However, this particular 99th Amendment was cancelled or struck down by the Supreme Court of India by declaring that it is unconstitutional. They again quote the basic structure and they declare that independence of judiciary is the basic structure. Therefore, any amount of having an influence in the appointment of judges cannot be tolerated. So, even till now, the appointment of judges are being made based on the collegium system. However, whether there is a merit system in the collegium or what reforms can be made in the collegium system is another hot ticket which has great amount of debate and discussion. In the classes, we will deal how judges are being appointed, how they remove the judges, what are the powers given to the Supreme Court of India and High Court. In addition to that, for High Court also, the appointments are being made only by the collegium model. So whether it is Supreme Court or the High Court, the second judge case holds true for both the cases. In this perspective, we will deal the chapter on judiciary, which is very important for the examination in the classes. Thank you.